All rise.
The Kosovo Specialist Chambers is now in session.
Please be seated. Madam Court Officer, please call the case.
Good afternoon, Your Honors. This is case CBC 2020-06. The Specialist Prosecutor versus Hashim Thaçi, Kadri Veseli, Recep Salimi, and Jakub Krasniqi.
Good afternoon. For the record, this is a status conference as previously scheduled. Mr. Thaçi and Mr. Krasniqi are appearing by video link with permission of the panel. Mr. Salimi and Mr. Veseli are present in court. Mr. Misitich, you made a request for this status conference. We give you the floor. We'd like you to indicate what you feel, what thoughts you'd like to share with us, and then we'll see how people react to it.
Thank you, Mr. President. I hope to be brief. As we're all aware, the SPO made submissions on May 21st as to how it would streamline the case, and that was pursuant to a discussion at the last status conference we had on streamlining the case, which was in March. We take note of the fact that the prosecution indicated that they were reducing their overall time estimate, or that the reductions or proposed reductions would reduce the overall time estimate by 40 hours, but we have concerns based on the rights of the accused to a speedy trial that we're not anywhere close to being able to finish by April of 2025. Obviously, we're not in control of that process, so we'd actually like to hear the prosecution's views on whether they think they're on track and how they intend to get there. But I will just tell you the math that we've done, and I'm hoping that the prosecution will tell us that our math is all wrong and that we're going to finish in the spring of 2025. At the prosecution pretrial or preparation conference in February of 2023, the SPO indicated that its estimate for time needed in direct was 545 hours. Using that as our starting point, we've received the statistics Friday afternoon of how much time has been used thus far, and the SPO has used 120 hours for direct examination. We've had 111 days in court, which means that on an average trial day, the SPO uses 1.08 hours per day for direct examination, based on the rate we're at for the past year and 1 month. We have 71 days left in court according to the existing calendar. We've projected out that for the first 3 months of 2025, we would have approximately 33 days of courtroom time if we start on January 14th and apply the 3 weeks on, 1 week off, 3 weeks on, 2 week off principle. That should get us to about 33 days, which means that we have about 104 days of trial days left before the 1st of April 2025. If we multiply that by the average of 1.08 hours of courtroom time used per day for SPO direct, that gets us to an additional 112 SPO hours between now and April 1st of next year. Combining the 112 with the 120 used so far, my math is that it would get us to 232 SPO hours of direct examination by April 1st of next year, leaving 313 hours left from their 545 hours estimated in February of 2025. Now, the latest filing on May 21st reduces that number by 40 hours, so that takes us to 273 hours left as of April 1, 2025. If we assume time savings with Rule 153 and 154 applications, and if we assume that the witnesses who've already testified, the SPO has used less time on direct that they had initially anticipated back in February of 2023, we say, let's say that's 75 hours of additional savings total. That still leaves 200 hours of SPO direct beginning on April 1, 2025. And if we apply that 1.08 hours of SPO direct per trial day, it would mean we would need an additional 216 courtroom days for the SPO to finish its case beginning on April 1, 2025. And that, if we apply about 100 courtroom days a year, that means the SPO case would rest sometime around May of 2027. Again, I'm not raising this to be argumentative. We're trying to figure out where we are in the case. I will be more than pleased if the SPO tells me that this is completely off and they do anticipate being on track for the spring of 2025. But our concern is the rights of the accused to an expeditious trial. The rules actually in Rule 116, Paragraph 1 and Paragraph 4, and Rule 118, Paragraph 1D, make specific reference to the fact that the panel shall take measures and adopt procedures in order to facilitate the fair and expeditious conduct of the trial proceedings. It authorizes the panel to issue orders as may be necessary to ensure fair and expeditious trial. And Rule 118, 1D says that the panel has the power to determine the time available to the specialist prosecutor for presenting evidence. So depending on what we hear today from the prosecution, if it doesn't appear that we're on track, then I intend to ask the panel to exercise its authority under those rules and to start setting specific limits as to how we're going to get to the end of the prosecution case in the spring of 2025. Those are our submissions.
Okay, while you're still standing then, and I appreciate your math. Haven't had a chance to check it all, but appreciate it. Assume for a moment that it's correct. What's your obligation in this?
Your Honor, believe me when I tell you I'm open to additional ideas.
That's not what the question is. What is your obligation, in your opinion, for expeditiousness?
Our obligation is not to waste time, is what I would say. But I don't think we've been wasting time. But I don't think, if I can just answer it this way, it's not on the accused to, or I should say that time saving can't be a function of taking away the accused's right to examine witnesses against him. So I believe in the last few months that actually the defense has taken affirmative steps to agree to more 153 applications. I think that the cross-examinations have been significantly shorter. We've reduced our time estimates for most every witness on cross-examination. And I'm open to hearing other ideas if there's something that we can do that doesn't sacrifice the rights of the accused to have the witnesses against them examined. We're certainly open to it. If the math, as you asked me, if the math is correct or even close to being correct, then we have a structural problem that I don't think is resolved simply by telling the defense to reduce cross-examination time. I will add, on top of your point, that the most recent statistics, and I think we're all in on this, because in terms of time spent examining witnesses, the panel itself is now third. There's 3 defense teams that have taken less time than the panel has taken in examining witnesses. So you know, in that sense, it's going to be a joint effort, and this is not intended, my submissions are not intended to point the finger at anybody. We have, I think, a structural issue, and I would like to hear from the prosecution that I'm wrong and that we're off, but if I'm not wrong, then I think we need to address it structurally.
Well, we'll get to the prosecution eventually.
Yeah.
And, but we brought up before the fact that there is an impact also by overestimating your cross-examination, which puts the prosecution in the position of not being able to back up witnesses sufficiently to take advantage of what you've done, which is hurry up your cross-examination. Hurry up is the wrong word, but to increase the efficiency of your cross-examination. And you've recently seen the documents that came from CMU. Maybe you haven't, but let me just review them briefly. You can sit down now. Let me just review them briefly. In the last 2 blocks of trial time, which is just basically 6 weeks of trial, the Thaçi defense, I'm not doing this in any particular order, I'm just how it happened to be on my desk at the time. Thaçi's defense estimated their cross-examination at 11 hours and 15 minutes. The actual time of cross-examination was 3 hours and 11 minutes. The total overestimate was 8 hours and 3 minutes. Actual time used was 28% of the total estimate. The Salimi defense estimated cross-examination time was 16 hours and 20 minutes. Actual time of cross-examination, 5 hours and 28 minutes, which is an overestimate of 10 hours and 51 minutes. Actual time used was 33% of the estimate. Krasniqi defense estimated cross-examination was 14 hours. The actual time of cross-examination was 3 hours and 23 minutes, which is an overestimation of 10 hours and 36 minutes. The actual time used was 23% of the estimate. The Thaçi defense estimated cross-examination was 26 hours and 30 minutes. The actual time of cross-examination was 13 hours and 35 minutes. The overestimation was right at 13 hours. The actual time used was 50% of the estimate. I'm not going to go into the victims' counsel because he's been quite judicious in using the time estimated for him. The SBO's estimated time in excess of actual time was 5 hours and 44 minutes. So using the time accounting by SMU, we see that a total of almost 48 hours that was estimated was in fact not used and resulted in the loss of opportunity to call additional witnesses that could not be called because we were leaving time primarily for cross-examination that didn't occur. Now, many times you individually have said you're going to eliminate some of your estimated time. But if that happens a few minutes before your cross-examination or right before the session starts in which you will be cross-examining, it doesn't do much good. It's important that we, in advance of time, take a realistic look at who's going to testify and what they're going to testify to and make our estimates accordingly. 48 hours of unused time represents almost 9 days of time that was estimated and then not used. That's a problem, and it has continued to be a problem. And I fully recognize the efforts to improve the efficiency of the cross-examination. There's no question. We can see that you are working together, you're cooperating with each other, you're discussing the cross-examination and being able to co-opt the process. I know you can't always do that. I know there are times when you can't. But it would be much more helpful if we could early on take a realistic look at cross-examination times. I'm not trying to blame you for everything. I'm just telling you that's one part of the process.
Yeah, and I do take that point, Mr. President. So I think hopefully the estimates will be closer to the time that we're actually going to need. But it strikes me that we didn't actually miss 9 days of courtroom time.
Well, we missed 2 days just in the last group.
One was, I think, because of 153 agreement on a witness. But
When did that get done? When did that get accomplished? That's the same thing.
I accept that, but there's also a function of this, which is that the reality of defense prep is that witnesses are not prepped a month in advance, right? So we're taking files and working as hard as we can to prep, a week in advance of the witness that's coming up. But that's why there's a little bit of that involved in there as well. But the point I wanted to make is I don't think we're losing, and I accept 2 days, but I don't think that's necessarily the issue, or at least if there's a way then to figure out how we can get more witnesses in the queue, if that does happen, because all of us have been in international criminal cases before, and I frankly don't know why it's happening in this case, and it didn't happen in other cases where, somehow it's a function of defense estimates that we don't have witnesses in the queue and ready to come on as soon as the witness before.
Well, they usually do, but sometimes they can't because they don't know how long you all are going to take, to be real honest.
Okay, but
But I've talked enough about
Okay,
that. That's one part of the puzzle. Now I want to hear from the others. Mr. Emerson's on his feet, so I'll hear from you.
Well, Your Honour, I don't want to take up, you can hear me okay, I don't want to take up more time discussing the responsibilities respectively as between the prosecution, who brings the case and has the obligation of presenting it efficiently, and the defence, who are doing their very best to estimate well in advance how long a witness is likely to be, then cutting it nearer the time if it looks as though once one's seen the proofing notes there is less time required. And then finally, and the only time this decision can be made, they've heard the cross-examination of the counsel before, and issues that they may well have been intending to take, and which sometimes take quite some time through translation, have been dealt with very ably by Mr. Misetic, for example. It is impossible. No court in the world with multiple defendants could expect defence teams to be able to estimate how much shorter their cross-examination might be, depending on what the previous counsel says. So with all due respect, it is entirely unfair and unjust to be putting the lack of efficiency in the prep. It is, with respect, lack of efficiency, because when a witness is finished, it's the prosecution's duty.
Try not to insult people.
I'm not insulting anybody.
Yes, you are. Just tell us what you think you can do.
And Mr. Emerson, maybe as an illustration of one such court, the ICTY, right, in some cases set limits
Exactly.
to cross-examination, which is exactly what we are discussing. So there are courts that set those limits for the defense and then left it to the various defendants to decide how much would go to each of the team.
Or invited them to say when a standard estimate needed to be expanded in advance.
Of course,
and I
of
suggested
course.
that to this panel right at the beginning as the right way forward, given the problems of time that the prosecution's estimates are bound to give rise to. But the fact of the matter is that and I can take the maths, I think, a bit more simply, we have, despite the slight shaving that came through from the prosecution, 101 at least witnesses left to be called, and we have so far, in just over a year, managed to hear 66. So that is the position. It was our understanding on this side of the room that Your Honours had intended and made clear to the prosecution that their time for the presentation of their case was 2 years. And to suggest that it's the defence's responsibility that they have left us in a situation where it's quite clear we are going to go way over that estimate if there isn't some a guillotine or time limit, whether it's on the defence or the prosecution, or either it has to be both, in terms of time and presentation. The fact of the matter is, and it does add up, you know, the Sealy defence has taken a total of 43 hours and 33 minutes. The panel has taken 44 hours and 46 minutes. and questions arising out of the panel's questions have taken 21 hours and 59 minutes. Now, as Mr. Masesic suggested, it's a shared responsibility to get this trial done within a reasonable time. But again, with respect, the implication that the responsibility rests on the defence, not the bench, who know in advance how long they've got to take.
And has said it is totally your fault. I'm just started here because Mr. Misitich asked for the status conference, and I'm giving you the opportunity to get out in front of this. I haven't started with the prosecution yet. Please give us a chance to talk to everybody before you start throwing darts at us, all right?
Well, I wasn't throwing darts.
Yes, you
at
are. Just please try
I'm sorry,
to...
I don't understand why you've accused me, first of all, of insulting somebody.
'Cause
I
you
don't
did.
know who. Well, could you tell me what I did to insult and who it was? I
Are
didn't
you
need
interested
to know,
in-
because you already criticised me and warned me.
Are you interested in trying to solve this problem?
I
Or are
am.
you interested in just standing and talking?
No, I'm very interested in trying to solve it.
Is there something else you want to say?
Yes, I'd like to know why you're accusing me of being insulting when I'm not.
I said you were insulting the prosecution, and you did.
In what way?
Whatever you said. I can't remember now. We've moved on. But please, just...
It doesn't seem fair to be treating a single defence counsel in this way every time he stands up and make criticisms which are about the way I present my arguments.
every
What I
time you
said
stand,
was that
every time you stand up?
it's happening a great
Is that the way
deal.
you want to leave it?
I don't think I've said anything at all to cause any offence at all, other than speaking quite normally and making submissions.
Okay. Is
And
there
if that-
anything else you want to say?
I was halfway through saying we are in a situation where the one party in the triumvirate of entities in this that cannot cut their estimates any more accurately until they've heard the previous cross-examination is the defence. And anybody who's ever defended knows that. So there is absolutely nothing that can be laid bare of the defence by way of criticism if what we're doing is, as we approach the moment we have to stand up, we're revising our estimates. Surely, if the impetus became one where you had to talk for as long as possible to keep your estimate full, the bench would be saying to us, well, why are you talking, you've gone on so long? I mean, the whole purpose of estimates is that they are estimates, and the defence, of all people, can't predict their estimates until they've heard what other people have asked. It would be the same as if the judges, in their questions, had to predict an estimate and then were criticised for not using the whole estimate they projected. Inevitably, judges, like counsel, are responding to the evidence as it emerges. And with the greatest of respect to the bench and the panel, there is nothing insulting in pointing that out.
Mr. Emerson, before you sit, did I understand your submission correctly that you are inviting us to set time limits on the defense cross-examination? I want to be sure I understand what you are saying.
What I said was at the beginning of the trial, I made the point that if we were going to get through this trial, a practice that had been adopted in the ICTY was to have a standard time limit. So prosecution, depending on the method of production, prosecution gets half an hour, defence gets an hour. But if the defence counsel wants more or less than that because they can see a witness is going to take time, then they notify the panel, explain their reasons in advance, and the panel rules upon it. But I mean, with a trial of this magnitude, which is now, it looks as though it's now been, we are now not even halfway through. We're looking at something that was going to extend quite probably, unless something is done, until 2027. Of course, there should be some limits imposed fairly and in a way that enables the defence to prepare their case. Absolutely. And for my part, find time limits a very useful way of focusing cross-examination on the most important issues. But I'm sure that I mean, if it's to be suggested that the defence have not acted conscientiously, and that that's the reason for it, then obviously I would resist that. But it's certainly one way of moving forward, yes. But then there have to be time limits on the judge's questions as well, of course.
Thank you.
There's no question that you did bring that up early on in the case, and I appreciate that. There was some resistance among others to the same concept, and I understood that as well. So we tried to leave it to self-policing up until now, but we may have to reconsider that. Mr. Roberts.
Thank you, Your Honour, and good afternoon. I think the example of the last 20 minutes shows the position we're in. We've just heard counsel for Mr. Thaçi and counsel for Mr. Emerson make a lot of the same submissions that we would have made. So if I'd given an estimate for my submissions, I would have put 20 minutes, but obviously now it's a little more than a couple. The only additional point I would make in terms of notifying the prosecution, for example, and the court of updates to our cross-examination times, one aspect that does affect that is when the preparation notes are provided to us. And obviously, the later the preparation notes are provided to us, we wait, and I'll be candid with you, I wait until I've received those, until I give any update, because I want to know what additional information has been sought or what may come from those, and that may affect my estimate significantly. So obviously, the earlier we're able to be provided with those, the earlier it gives us the opportunity to be able to update you in a realistic manner. And I think we're all very, very keen to do that. We're not giving these estimates for fun. We're doing it to be as transparent and helpful as possible, but obviously with the limitations that places us in. So that's the one thing that I would suggest would assist me anyway. Thank you.
That's a point well taken, and we will discuss that. Mr. Ellis or Ms. Alejandra, either one.
Yes, thank you, Your Honour. Good afternoon. Your Honour, we're in the position going forth where we try as we might to coordinate in advance. We do often find points that we would have taken are being dealt with well and in advance of our questioning. That's at least a significant part of the explanation for why our hours have been less than what we have estimated. I think it's also true that in the past block that there have been some live witnesses, and it's particularly difficult to estimate in advance where the witness is wholly giving evidence viva voce, because our cross-examination depends on what they actually say in court as opposed to what's in the written documents. In an attempt to be constructive, can I first of all agree with the point that Mr. Roberts made, which is that often the trigger for us to reduce our cross-examination estimate is the chance to review the preparation notes. And if we could see that earlier, then we might well be able to indicate earlier any reductions. Secondly, I wonder if it's been helpful in past blocks that the reserve witness coming at the end of the block is somebody who's anticipated to give evidence by video link. That perhaps makes it easier to slot them in, and you don't have the difficulty of a witness waiting in The Hague who may or may not be called. It would seem to us it might be useful if we're, of course, on notice of who that's going to be. Perhaps the video link would alleviate some of the difficulties associated with that. Those are my observations at this stage. We also see that the core problem is just the number of witnesses left to go through. We don't anticipate that the reductions so far are enough to get us there in time for an April 25 finish date.
Those are also points well taken. I will say that sometimes the video link witness is more complicated to get worked in if they're far away, because we have to get personnel there to deal with it. And that can be somewhat difficult at times too, but I understand your position. All right, Mr. Prosecutor, you don't get off the hook on this. We're going to talk to you about it too. And I certainly started, as I said, I started over here because Mr. Misitich obviously had something he wanted to say, and he has, and others have too. So tell us how you're going to get to April, because we don't seem to have much of a feeling that we're going to give that up.
Understood. And we're interested in solving this. We actually think we have positive steps to report since the February status conference. I can give some numbers along these lines. As of the 21 February status conference, we completed 46 witnesses, and we'd now announced 144 witnesses on our list left to call. And that's live and Rule 154. It's been about 3 months since that hearing, and in that time, we've called 20 witnesses, and that is an accelerated pace. In our notice of 21 May 2024, which has been discussed already, and it's filing FO 2325, we announced a further 23 witnesses as no longer needing to provide in-court testimony in the SPO case. So with the 20 called witnesses and the 23 streamlined witnesses, the total is now down to just over 100 witnesses. And I know Mr. Emerson had said 101. Our numbers are actually 104. There have been some Rule 153 rulings where witnesses have had to appear, including one today. So it's slightly over 100 witnesses. Particularly when recalling the exchange at the end of the last status conference, when the court indicated very clearly that cutting 3 witnesses was not going to be nearly streamlining enough, and this is page 12,807 of the transcript, we would submit that we have responded meaningfully to the court's request. And that response, we note, has been coupled with measures by the panel to improve efficiency, adding hearing hours, prompting reductions in certain cross-examination estimates, which have helped to facilitate the new pace. It's not done. We will continue to review the impact of ongoing witness testimony and document admission, as well as hopefully the continued acceleration of the witness testimony. As has been noted and foreshadowed previously, this notice is part of an ongoing process, and we continue to do everything we can to present an efficient and expeditious case. We are nowhere near May 2027 on any of these numbers. And Mr. Misitich's numbers, it's not enough time to fully contextualize them all, but even just from hearing them, starting from February 2023, doesn't account for, one, all of the streamlining that's happened since then, and also those were estimated hours indirect. The actual direct examination hours is significantly less than that. And it also doesn't account for the accelerated pace. The pace of the witness examination has changed since February of this year, and we hope that that trajectory is going to continue. Just a couple of last points in relation to the discussion about cross-examination and really focusing on repetitive questioning, because this was the issue raised by the panel in February of this year. It is always welcomed when cross-examination estimates are reduced. No one wants repetitive questioning, and it's better to announce it in some form than not to announce it at all. But we have the same issue that's been identified by the panel, which is that we need more long-range information of these cross-examination estimates reductions in order to be able to logistically leverage that into getting new witnesses into the courtroom. When Mr. Misitich says they're preparing these witnesses the week before, I believe him. That explains a lot of these late reductions that we're seeing, but that can't be how this works. You can't prepare these witnesses the week before, and it calls into question what are the numbers in the responses to the notifications of witnesses that we provide well in advance if the defense is only really turning their attention to these witnesses the week before. And we would invite the panel to set just some sort of reasonable time frame for the defense to be affirming and reducing their cross-examination estimates in a sufficient amount of time such that we actually can repurpose the court time and make further progress. And we do think that there's more efficiencies that can be gained there.
Won't finish the prep notes until 2 days before the actual hearing. How are you going to get that? It isn't going to help you any if they reduce their time estimate after that. You're not going to be able to get a witness in there, so it doesn't do any good unless you can get the prep note done a little earlier.
We certainly acknowledge that there are certain preparation notes that significantly change the complexion of a witness and that may well change the cross-examination time. I don't think that's most of them. I think most of the preparation notes are more or less in line with what the witness has said before and really shouldn't be prompting a sea change in the examination. I think what is really being seen here is what Mr. Misitich was alluding to. The time just before the witness testimony is the moment when the defense is able to fully appreciate what it is intending to do. And we certainly would understand if a preparation note prompted real changes in the examination, but we actually think that there's more efficiencies that can be gained from that. We also take the point that preparation notes should be provided as early as possible, and that the 24-hour deadline is the last moment when it needs to be provided. And we are trying, and we think have succeeded in providing these notes additional days in advance of testimony whenever we can.
What about if we change the time necessary prior to testimony for the prep notes? Can you deal with that? Well, you'd have to if we do.
That was exactly what I was going to say.
Okay.
I have a couple of questions for you, Mr. Halling, on some of the suggestions that were helpfully made by the defense and one of my own. The first one is just a follow-up to Judge Smith's question. Realistically, how long before a witness would you be able to provide preparation notes? And the truth is, sometimes in between, I do agree with you that some are more important than others in terms of preparation, but at least for big witnesses, let's put it that way, how much earlier would you be able to provide that to the defense and to the panel?
Yes. The nature of the preparation session is that it is shortly before the examination. And so it's after the witnesses have traveled, which means that realistically, we aren't even able to commence a preparation session until less than a week before the examination. We can and have provided them regularly 2 days in advance, 3 days in advance, but we're not able to do it 2 months in advance. That wouldn't, in our mind, be a preparation session. That would be something else.
I don't think anybody expects it 2 months in advance. Correct me if I'm wrong, but a reasonable period of time is what we're looking for.
So the answer is about a week.
That is the about a week before, and again, some people are here more or less time, but that's when they approximately travel, and then they need an opportunity because part of the prep session requires them to read all of their prior statements so as to be able to be in a position to articulate any corrections. So they need a window of time, which sometimes can last for a couple days or more, in order to read everything before the preparation session can commence. And so we wouldn't want a deadline set so far in advance that we are inconveniencing witnesses by having them be here just waiting around for too long. But I mean, I think our practice shows that we are commonly able to do it in advance of the one-day deadline.
Your Honour, if I would be so bold as to just intervene then, I don't see any reason why it can't be done earlier than that. I think especially by video link, there's no reason why part of the preparation session, as I believe many of them have been done, previous statements can be provided, they can be discussed by video link. We don't need to inconvenience every witness by dragging them over here a long time in advance, but that certain amount of information can with a little bit of effort and a bit of planning be done, for example, in that manner. I think the one advantage of the pandemic is that a lot of things can be done by video link that actually previously people thought had to be done in person. So just in terms of planning ahead, I don't see any reason, for example, with some of the bigger witnesses coming up now in the near future, that those notes can't be provided 7 or 8, 9, 10 days in advance, especially when we're talking about interviews that have taken place 4 or 5 years ago with the SBO and are quite long. There is a certain amount of information that needs to be got through by those witnesses. So the earlier that started, and if video link by necessary, the earlier we can get hold of the information, and then we can start providing that helpful information to the prosecution. Thank you.
Want to respond to that at all?
That doing something like that, you can't just do video link. You still need staff to travel to where the witness is in order to facilitate the session. So that is a massive expense for us to have to fly to where a witness is in order to conduct a preparation session, only for everyone to be flying to The Hague shortly before testimony. The only other point on this I wanted to emphasize is that part of the witness preparation procedure as designed by this panel is to help secure the witness's well-being when they testify. And it is in part coming and being about ready to testify and trying to make people feel comfortable shortly before they come that is part of the witness preparation procedure in the conduct of proceedings. And if you do it too far in advance in an abstract setting, you're not going to have the kind of efficiency of the witness kind of being here and getting ready to testify if you do it in a way that is so far detached from their actual testimony.
If you can tell us without violating some rule that I don't know about, how long do you usually have a witness here before they testify?
It does vary. I think I can give an approximate answer that wouldn't cause any issues. So witnesses have to travel. They do need to do a certain familiarization procedure with the registry, and I don't think it takes approximately a day is budgeted for that. They need an opportunity to read their statements, and then we need the opportunity to both conduct the preparation session and make the notes, which takes a little bit of time after the session in order to make sure everything is properly memorialized. And so if you run that from end to end, it's often the better part of a week that all of that needs to be done. And so we try and set it up so that witnesses aren't just sitting around waiting to testify for anything more than the minimum.
When is it most optimum for you, since you're calling another witness? How much time do you need to get another witness in place?
I mean, the answer is always going to be as long as possible, but certainly.
In other words, how much time do they have to give you, for example, that they're going to cut short their cross-examination in order for you to react and get us a witness?
Yeah, certainly if it's provided in the response to the notice, which is often multiple months in advance of testimony, then we comfortably, and we use those numbers. If it's a month in advance of the testimony, it starts getting a little tight for logistical arrangements, including for the witnesses themselves, not all of whom are free at all times. But if we can get a meaningful estimate that far in advance, we can work with that and make alternative arrangements often.
But I think they're telling you that they need to see the notes before they can make that meaningful assessment, and that's going to happen at no more than a week before the testimony.
And I guess that's the point that we challenge. We do accept that preparation notes might necessitate changes in cross-examination estimates, but we don't think that they are causing such a sea change as to be a kind of precondition to getting valuable numbers. The panel has asked the defense to provide their cross-examination estimates well in advance of receiving any preparation note, and that makes total sense, and there's no reason why that shouldn't be possible.
I have another question for you, Mr. Harding, and it's perhaps more of a reassurance from you that I'm seeking than truly an answer. But I'll ask it in that way. Now we have about a year of evidence behind us, and you'd be quite aware of what evidence you have or you think you have on your case. I want to understand what efforts are being made to make that assessment with a view, A, potentially to drop more witnesses, and or B, to make use of existing procedural rules, in particular 153 and 154, to try to expedite the rest of the trial, in particular if the evidence yet to be called is repetitious or corroborating.
Yes, Your Honor. And yes, there's a lot of factors that go into the assessments on whether or not witnesses are streamlined, as I called it. One of the primary factors, if not the primary factor, is the kind of substitutability of evidence. If witnesses on the same topic have already been heard or documents have already been admitted that cover the witness's testimony, that is a major factor in deciding whether it is still necessary to call a witness reduce them to writing, drop them entirely. There are other factors as well, including depending on the importance of the evidence in the case, the level of cooperation of the witness, procedural developments in the trial. It's not just that, but this is something that we are actively looking at, and it's part of why the streamlining has to happen in waves, because we need to hear certain evidence and make sure that it got admitted the way we expected it to before making certain streamlining decisions.
And just in terms of planning, Mr. Mišetić was maybe overstating his point that he prepares the week before, but what I understand him to say is fine-tuning and finalization happen at that point. Now, one thing which maybe you could do to try to help the process is if and when you have decided not to call a witness, in order for the defense not to have to prepare for that witness, and or when you have decided to 154, 153 the witness, would be to make that notification ASAP to the defense so that they are not preparing for witnesses who are either not going to come or which you offer to tender in writing.
Yes, and that's actually already our policy, and some of it is even in accordance with past directions of the panel. For Rule 153 witnesses, for instance, before any Rule 153 application is filed, we send an inter partes notice to the defense indicating the witnesses that are going to be Rule 153. And as was seen in the Rule 153 application where we're replying today, there were some witnesses in that application that were Rule 154, and we announced that they were moving in that notice in advance. So we fully appreciate that. We're trying to do it.
Thank you.
Can I just ask a question? Mr. Halling, several months ago, and correct me if I'm wrong about this, I think you made it clear that prosecution was confident that it would meet the April 2025 deadline. And today you talked about an accelerated schedule. Now, when I look at the mathematics of this, it's not at all clear to me how the prosecution, even taking into account the accelerated pace, can possibly meet the April 2025 deadline. So could I just invite you to articulate a little more clearly how precisely confident are you now that you can meet the April 2025 deadline? And if you're very confident, why are you so confident?
Yes, I'll make reference to the way that I said it in February, that we weren't guaranteeing that we were going to meet that deadline, but we weren't conceding that we couldn't either. I will say that on accelerated pace alone, it's not enough. We fully recognize that, which is why we said that we have another streamlining round anticipated in October. We still need to make further reductions in conjunction with an accelerated pace to make it. I can say that the chances of hitting the deadline have improved since February. We are seeing positive steps. We are seeing improvement. And so I can't guarantee it one way or the other, but this is something where the accelerated pace combined with the streamlining is the key to hitting that target date. And we have seen significant progress on both fronts. It needs to continue on both fronts.
May I respond?
Certainly.
Mr. President, first, I'm glad that I'm wrong on my math, at least according to the prosecution. But I am concerned now with the last answer because it's not a commitment that we're going to reach April 2025. And if we wait until October for the next round of streamlining, it's basically going to be a fait accompli that you're going to have to extend the deadline because there'll be relatively few weeks or months left before that deadline, and then the application by the prosecution is going to be, we can't meet the deadline and we have so many important witnesses left and you have to extend the deadline, et cetera, which is why I wanted to deal with this now when we still have 11 months before that deadline to say, okay, let's figure it out. Again, accepting that we need to improve our cross-examination time estimates, I still don't think that that's the reason that we're, off on reaching the April 2025 deadline. If we've cost it, a few weeks, then mea culpa, but it's not a few months or years.
I'll be perfectly frank. The reason we used that particular question about accuracy is because if we don't, the prosecution's going to come back and say, the reason we couldn't get this finished was because we couldn't get the reserve witnesses in because we got notified too late. I don't want to be in that position. I'm trying to avoid that. And the way we can avoid that is by everybody doing their best to make the estimate the best you can. I don't expect you to make it 100% accurate. I don't think anybody in this court has had a circumstance that they asked for some additional time on their questioning that they didn't get it.
Yeah.
I understand you can't
And I
fit
was-
into a tight category on timing all the time. Go ahead.
And I was just going to say that on our behalf, I suspect what I'm going to do going forward is precisely that, is reduce the time estimates, and then if I need a little more leeway, ask you to just trust us on it and say, and if we start getting an irrelevant time or wasting time, then fine.
You
But
tell us why, and it's usually good enough.
then that may be the approach that I take going forward on this. I would not want firm limits on cross. I appreciate that. And one of the functions is that we have the misfortune of being first. And so it might be that our perspective is different. And if we were not first, I'll put it that way, we also may be focusing on very discrete issues related solely to Mr. Thaçi, and then our crosses would be shorter. But to get back to my fundamental point, which is we certainly don't want to wait until October to figure out what's the structural problem here. And so I'll commit that our cross-examination times will be lowered, but I think we do need to assess, again, the length of the witness list and deal with it now so that we hit the deadline.
My very next question to the prosecution was, why do you have to wait till October? I mean, I think you know what this case is about. You know what the witnesses are going to testify to. You know those witnesses that are somewhat repetitious. You know that you've got maybe too many crime-based witnesses. I don't know why you can't get on with it.
We know all of that. You're correct. What we don't know is if the witnesses are going to come to court and come up to proof on the points that we expect them to. And until we have clarity on that, and there are big witnesses coming in the next few months, it's hard for us to make decisions to streamline people who are cumulative on paper but may not be cumulative in fact. And this is an issue that is also important for our streamlining conversations. I mean, to be clear, and I hope it's apparent from my submissions, we are still working towards the April 2025 deadline. I can say all the things that have been said before. It was said at a moment before the trial because it had to be. It didn't take into account the actual hearing hours, the actual cross estimates, obstruction and other barriers. We're still here. We are still continuing to work towards it anyway. And I have no doubt that if we file an extension of time request and it is not to the panel's liking, it will not be a fait accompli, it will be rejected. And we know that we need to be accountable throughout, and we would say that we are.
Mr. Halling, just a follow-up on your last submissions. I think the panel understands that there are issues, to use your words, of whether witnesses are going to come up to proof on these points. Now, my question is this. You could figure this today, or you could figure this out in 6 months. Is there any benefit in time passing, to the extent you can say that in a public setting? If a witness is not going to deliver on your expectations, having that knowledge today might be more useful than to have it in 6 months.
I think I follow. I'll give an answer, and if it's not fully responsive, please let me know. It is not predictable, in part due to the climate of witness intimidation in this case, when a witness is going to suddenly diverge from what their testimony was anticipated to be. And so we have an understanding that if certain witnesses happen in this way, or if certain developments unfold, then witnesses may be able to be dropped down the line. But it's not something that we can actually make a final decision on until we have actually elicited the evidence that we were expecting. And so we are calling people in the next few months that we think are going to be very helpful in deciding future streamlining decisions. It's also dependent on procedural developments. And I gave an example of adjudicated facts from the Mustafa case at the February hearing. Another example would be the pending appeal on the admissibility of the accused statements in this case, which we consider to be extremely important evidence. And we think that it's admitted, it's pending appeal. And we would not want to make a decision assuming anything, given that the matter is pending appeal. And so because it's conditional on certain events, we do have to wait, but it doesn't mean that we are not actively streamlining the entire time.
Thank you.
Just while we have you here, at least in my view, and I think in the panel's view, the 154 rule is very helpful, but it is not helpful if the prosecution asks the same questions that are already asked in the statement itself. It wastes a lot of time. I can't say it's a huge thing. The prosecution has limited its direct examination, but there have been times when a good deal of it wasn't very necessary, and I'd like that to be attended to.
Yes, and Your Honor said the same thing in the February status conference.
I didn't see much improvement in that.
In this regard, we will say, though, most of our witnesses are Rule 154. In the 20 witnesses that we called since February 21st, we only used 22 direct examination hours. We really are trying to prioritize cutting out repetitive questioning, and we're mindful of the direction of the panel.
There are still some room for improvement, that's all I'm saying. And I do want to re-emphasize that the panel has noticed a remarkable improvement in the amount of time used in cross-examination. That's not what the complaint was about. The complaint was just about the estimates. And I appreciate that, and I don't see anything vastly unreasonable about that type of cross-examination that's been going on recently. It's been efficient. It's been cooperative among the defense panels or the defense teams, and we do appreciate that. We are not inclined to want this matter to go beyond April, and I don't think anybody else is either. At least I hope that's the case. There's nothing to be gained by it. There's something to be lost by your clients and something to be lost by the prosecution if we start cutting things ourselves, because you're not going to like what we cut. Your cuts are going to be a lot more important to you than ours. So, anybody else have anything they'd like to bring up? I'll give you one more chance to go around. Is there anything you'd like to add, Mr. Misitich?
Nothing more.
Mr. Vasily has a difficulty, I think.
What?
Mr. Vasily was raising his hand.
Oh, okay. Mr. Vasily, you had your hand up. You had something you wanted to say, or okay? Ms. Rowe.
Mr. Vasily is keen to address the court, but in advance of that, perhaps if I could be of some assistance. Your Honour has been very keen from the outset to gain from us some constructive suggestions as to how we could do better or how we could move forward. And we have some suggestions as to how that might come about. One of those is, as Your Honour will be aware, in this block we have 3 reserve witnesses. 2 of those witnesses are video link witnesses, and they are the type of witnesses for whom that type of testimony works very well. But it also means that they are essentially on standby to give evidence when and if required in this block. Now, in our submission, there are numerous other witnesses of a similar nature who could, and in our submission should, be on standby at any given time for the blocks that we have going forward. Because if the SPO were in a position to do so, we do not have the difficulty of witnesses travelling, the difficulty of extended prep sessions. They would be in their domestic jurisdictions, and they would be available on standby to fill the gaps that we are finding ourselves occasionally coming across. And the way that we may well do things in this 3-week block would be a good example of how we could seek to do that in the future. And we would invite and suggest the SPO to look to do that, as that may well be a way of saving time in the future. those witnesses tend to be crime-based witnesses. Now, linked to that is an additional issue which appears to have arisen, which during inter-parties discussions and during 153 submissions, both in filings and in communication between the parties, what the defence have sought to do, particularly in recent months with Your Honour's direction to reduce the case and seek to work together to do so, we have sought on a regular basis to identify to the SPO the witnesses that in our view do not assist the panel with the ultimate issues that they have to determine in this case, and who are witnesses who do not go directly to crimes on the indictment, and therefore in our submission are witnesses that could be dispensed with. And unfortunately, in each and every occasion, those suggestions have been rebuked by the prosecution. We have noticed, and it is clear from the last update that we have received from the prosecution, that all but one of the witnesses sought to be dropped are not crime-based. And that came as some concern to the defence, because as has been the basis of much of this discussion, is that the form and basis of the evidence upon which there is more agreement is the crime base. Yet there seems to be a reluctance or a resistance on the part of the SPO to dispense with some of that crime-based evidence. And we would invite the panel to encourage the SPO, in particular, to assess the crime-based evidence that is duplicative or unnecessary when it comes to the panel's ultimate issues in this case, because there is quite a considerable lack of that sort of evidence being dispensed with. And we are concerned that perhaps it may be that there is a policy not to dispense with victims or crime-based testimony, which we hope is not the case, but we would like to simply highlight that as a pattern that we have seen emerge. The third, perhaps, suggestion would we would invite. Perhaps it's more of a feature of domestic jurisdictions, but while the prosecution, of course, in good faith, makes submissions that they anticipate being able to finish this trial by April of next year, in our submission, what might be a constructive exercise is for them to concretely map out how that might be achieved, to take the weeks that we have, to take the witnesses that they have, examine them thematically, examine the time that they anticipate those witnesses to take. And in essence, of course not in circumstances where they would be held to it, but where they would essentially map out the case for the rest of the year. These are the witnesses we anticipate calling in September. These are the witnesses we anticipate calling in October. Of course, they cannot be held to that. It's too early for that to be the case. But were they to be required to seek to create that batting order and to seek to narrow their minds in such a respect, all parties would have a far better idea of how close or how far away we are from that deadline. And the final matter, Your Honour, of course, we've now had the statistics in relation to time spent asking questions. And one of the issues that must be dealt with and cannot, unfortunately, be ignored is the time taken by judges' questions. And perhaps in that respect, the judges now, as has been identified by my learned friend, the panel takes more time than 3 of the defence teams, which is, of course, a significant proportion of examination time. But one of the features that has emerged and continues to emerge from the panel's questions is that the panel often seeks to open up new issues that are not relied upon by the prosecution in calling their case, seeks to elicit evidence that is not part of the prosecution case, and seeks to explore issues that are not raised by the defence in cross-examination. Now, of course, that can't be anticipated by the defence, and that therefore then in turn leads to extended defence cross-examination. But also what that does is broaden the issues in the case, extend the case, and take more time. And we would perhaps invite the panel to consider whether or not the extent to which new issues, new documents, new areas are explored and introduced is necessary when looking at the issues on the case that the SPO have sought to bring. And those are the 4 suggestions perhaps we hoped we could assist with. And I understand that Mr. Vasili is conscious that he would like to address the court, and if I could turn to him at this time, if Your Honour would allow.
I have no idea what he wants to address the court about.
Your Honour, I don't myself know the content of the submission he'd like to make, but I'm conscious he's very anxious to do so.
Yeah, but they don't.
Why don't you find out from him what it is that he wants to discuss?
I am conscious that it relates to proceedings today and the issues that have been discussed today, so I am confident that his submissions will be relevant. And it is only in those circumstances that I invite the panel to hear from him.
And he understands that he will be on the record.
He does.
All right. Mr. Vasili? Go ahead. Please, briefly, though.
Thank you very much, Your Honor, honorable panel. I want to thank every person who spoke before me in relation to the subject matter today. Allow me to be very brief in what I have to say and straightforward with you, because it is in the public interest what I'm about to say. There are two matters. The first one has to do with the duration of these proceedings. From day one, when we enter this courtroom, the prosecution transparently asked for 545 hours. From the first day, as a matter of fact, we all knew that, having in mind the proceedings that were to take place in this courtroom, there would be needed 4 years for the prosecution to use those 545 hours. Even if the defense or you panel members did not ask any question at all. What I want to say is the following. I believe it is in the interest of the public, and not only in our interest as accused, for someone to take a responsibility for the decision that these proceedings must be fair, transparent for the people of Kosovo, to respect the procedures and the laws and the Constitution of the Republic of Kosovo, but also to preserve and to guarantee a fair and expeditious and reasonable trial time. As an accused, I am afraid that if we do not comply with these principles, this will not impact only our individual fate, but it will also send a message to the people of Kosovo who consciously, awareingly, and with trust and confidence establish this court. For you as our partners, international partners, and we should not in any event violate this trust, which is the rule of law and international justice. Also, I want to stress something that has to do with me as an accused and my defense counsel, my lawyer. Honorable Judge, you have a lengthy experience, but I see that a communication which is not professional or normal. As an accused, I have the right to send a message. I wouldn't like things to be prejudged, those things that are outside my reality. I'm referring here in particular to the communication with my legal representative, Mr. Ben Emerson.
Vasili? Anybody else have anything?
Yes.
Just very briefly, Mr. President, I want to thank you for scheduling this conference, the prosecution for making efforts to make sure we stick to the April deadline. The one thought that crossed my mind, having considered Mr. Holling's comments, is if the issue is whether witnesses who they're anticipating calling, for example, in the next few months, testify in a manner that they're anticipating that they testify, then consistent with what counsel for Mr. Vasili stated, if there can be some way of sort of policing that, in other words, and I don't need to see the list myself, speaking for our defense, if it's ex parte to the panel as to who those witnesses are, so that you're aware that these are the witnesses that they want to put up first, if I can call them the primary witnesses, and then if needed, then there's this batch of reserve witnesses, and that if they could map out, here's how we're getting to April 2024, I would be happy even if it's just to you on an ex parte basis, so that there's some record of, that you can keep track of, to know that, okay, yes, this witness didn't testify in that matter, so they're going to call these 2 or 3 witnesses in additional, then fine. But I just don't want to lose control of the process and not be aware until October of where we are. Thank you.
Thank you, Judge Smith. I have a question. Not sure whether it will be the final question, but a question for the prosecution. Mr. Prosecutor, you can be sure that we, the judges, also have to prepare for each individual witness, as you can see from the questions that we ask, because we think they are relevant to comply with our obligation under the KSC's legal framework to seek and determine the truth. However, it's very, very difficult to prepare for a witness when we have heard the last witness to a specific incident weeks or sometimes even months or a year before. So my question is, wouldn't it make more sense to call witnesses, if possible, of course, to an incident together, or at least within the same witness block, especially in cases where 2 or more witnesses come from the same family? Thank you.
Thank you, Your Honor. And I believe a similar question was asked of us at the status conference in February. So this is part of our witness scheduling considerations. And there were 2 German witnesses about the same crime sites, and we called them right next to each other back to back. So we do take this into account.
That was much appreciated.
I'm glad. But there are also competing considerations, and one of them is related to the logistics of streamlining. We have several witnesses from a particular family or in relation to a particular site. Those can be prime candidates for streamlining. But if you line them up all in a row, you may not be able to actually repurpose the court time if they are all scheduled and you learn 3 days before that someone is cumulative. So sometimes people are grouped together and sometimes they're spaced out. It's dependent on other things as well, such as witness availability. The panel has been consistent in telling us that this is something that they appreciate. It's certainly something that we try and emphasize in our scheduling. It doesn't always happen for these reasons, and if there's any particular witness where the panel considers that it would be difficult to call them in the order because of judicial preparation time, we will obviously make necessary adjustments accordingly.
Thank you.
I'd be interested to hear your response, too, to this suggestion about mapping out where you're going, perhaps even on an ex parte basis or confidential basis. If you think it's possible, if you think it's something you could do or don't, or have a reason not to do it.
I mean, some of what has been discussed in those proposals is what's happening in this status conference, and some things about the panel policing the progression of our case comes from submissions like this, the rules of procedure and evidence. It's not strictly necessary to set up additional procedures in order to achieve the effect the defense wants. There are certain aspects to our streamlining procedure that we would consider to be internal work product. There are other parts of our streamlining procedure that we might be able to be more forthcoming with the panel than in a public inter partes setting. So it's a lot of what is being discussed in these proposals is already happening. And if your honors are ever interested in having a status conference, even an ex parte status conference on this, we're always available.
That might be a solution partially to get to what you and Ms. Rowan were both talking about. But we'll consider that. Anything else from the panel? Anything else from any of you? Yeah, Mr. Ellis.
Your Honour, if we're discussing trying to estimate future dates for the case, we would be interested if there's any possible indication at this stage as to whether Victims' Counsel intends to present evidence.
First of all, Mr. Laws, is there anything you'd like to bring up in connection with this long discussion? Because, as I said, you certainly haven't abused the process in any way. Not that anybody else has abused it either, but.
No, we're conscious that the time we take up comes out of the prosecution's time that's been allotted, and that the broader interests of the victims are in the prosecution having sufficient time to call as many of them as possible. So we try, and also it's fair to say, obviously, that the issues that we're dealing with are not anything like the magnitude of the issues being dealt with by the parties. That's fair. So we don't think it's a topic on which we can make any very useful submissions. But thank you for inviting us.
To answer the question that was asked, do you have any, without binding you to anything, is your present indication going to be that you will call witnesses in your own behalf?
It's something which we're obviously considering. I don't want to give an answer now, if that's all right, because we're at least a year away from that arising. But it's something which we are considering. The shape and the scope of the case that we put on is not at all set in stone now and won't be for some months. There are other issues as well to raise on the topic of the victim's case, but I have it in mind to raise one in particular, which is reparations inter partes before troubling the court with it, because it's potentially quite a large topic, and there's more than one way that it can be approached, and I intend to approach my colleagues opposite in the relatively near future in relation to that.
Thank you, Mr. Laws. Thank you to everybody for your candor. I hope we can come up with some solutions. We will consider all of the suggestions made and try to adopt something that makes sense for everybody and is fair to everybody. So we are adjourned.
All rise. All rise.
Be seated. I note that Mr. Thaçi and Mr. Krasniqi have waived their right to be present in the courtroom and are following the hearing via video link. Mr. Vaseli and Mr. Salimi are present in court today. We will start hearing the evidence of prosecution witness W04305, who will testify via video conference as granted by the panel in F02308. As you know, today, and if needed tomorrow, we will be sitting from 4:30 to 7:30 p.m. with a 15-minute break between 6 and 6:15 p.m. I thank the parties and the participants and the court officers and stenographers and interpreters and security officers for accommodating this altered sitting schedule. One brief matter, the Salimi defense and the Vaseli defense on Friday, 24 May, requested the panel to issue a briefing schedule for submissions concerning the admissibility under Rule 138 of the materials underlying the SBO's request to amend the exhibit list and the Thaçi defense request for exclusion in limine. The panel notifies the parties that it will issue a briefing schedule after the issuance of the Court of Appeals panel decision on the interlocutory appeals regarding these materials. No question we will issue it, but we just wanted to wait until we get that in order for it to be more timely and to perhaps take into consideration all the circumstances. So, Madam Usher, you may bring the witness in. Or Mr. Usher, I'm sorry, I couldn't see him. Mr. Court Officer, can you aim the camera up a bit? We're looking at your belt. There. Good morning, witness. The court usher will now provide you with a text of the solemn declaration that which you are asked to take pursuant to Rule 141, Paragraph 2. Please.
Good morning. Conscious of the significance of my testimony and my legal responsibility, I solemnly declare that I will tell the truth, the whole truth, and nothing but the truth, and that I shall not withhold anything which has come to my knowledge.
Be seated now. You can bring the chair back up.
Thank you.
Your Honor, I can confirm that present in the remote room are the witness W04304 and myself, Officer. Thank you.
Thank you very much, Mr. Court Officer. Witness, are you hearing me all right?
Yes.
Witness, today we will start your testimony, which is expected to last approximately 3 hours. As you may know, the prosecution will ask you questions first. Once they are finished, the defense has the right to ask questions of you, and members of the panel might have some questions for you as well. The prosecution estimate for your examination is 30 minutes. Victims' counsel will take approximately 15 minutes for questions. The defense estimates that it will need approximately 2.5 hours. And as regards each estimate, we hope that the counsel will be judicious in their use of their time. The panel may also allow redirect examination by the prosecution if conditions for it are met. Witness, please try to answer the questions clearly with short sentences. If you don't understand a question, feel free to ask counsel to repeat the question or tell them that you don't understand and they will clarify. Also, please try to indicate the basis of your knowledge of facts and circumstances that you will be asked about. In the event you are asked by the SBO to attest to some corrections made regarding your statements, you are reminded to confirm on the record that the written statement, as corrected by the list of corrections, accurately reflects your declaration. Please also speak into the microphone and wait 5 seconds before answering a question, and then speak at a slow pace for the interpreters to catch up. During the next days, while you are giving evidence in this court, you are not allowed to discuss with anyone the content of your testimony outside of the courtroom. If any person asks you questions outside the court about your testimony, please let us know. Please stop talking if I ask you to do so, and also stop talking if you see me raise my hand. These indications mean that I need to give you an instruction. If you feel the need to take breaks, please make an indication and we will accommodate you. We begin with questions from the prosecution. Mr. Quick, you have the floor.
Thank you, Your Honor. Hello, Mr. Witness. Can you hear me okay?
Yes, I can. Hello.
But I will introduce myself again. I am Nathan Quick with the SPO. I will be asking you some questions. I expect that my questioning will take less than 30 minutes. As I explained during your preparation session, rather than asking you questions about every relevant issue that you may have information about, it may be possible to admit some of your prior statements containing such information into evidence. In order to do so, there are a number of procedural steps to follow, which I will turn to after establishing your identity. Your Honor, if we could move into private session to protect the witness's identity.
Please into private session, Madam Court Officer.
Your Honor, we're in public session.
Thank you. Witness, before your testimony today, were you given the opportunity to make clarifications and corrections to your prior statements?
Yes, I was.
Do you recall these clarifications and corrections being included in a note, which was read back to you?
Yes, I do.
Being asked to confirm that the information in this note reflected your account fully and accurately?
Yes, I do.
Court officer, if we can please pull up preparation note 1. It's ERN 121136 to 121140, page 1. That should not be shown to the public. Witness, can you see a document on your screen?
Yes.
This is the note that was read back to you and that you confirmed at your preparation session. Court officer, if we can please go to page 4 of this note. Witness, on your screen, on this document, there's a chart at the bottom of the page which lists 3 statements by description and date. I don't want you to read or say out loud any of the information about these statements, as it may identify you. But if you can please have a look at the descriptions and the dates of those statements.
Yes, they are correct.
Thank you. Court officer, if we can please move to page 5 of the notes. And witness, the chart continues on this page, and there's a fourth statement listed, including a description and a date. Again, please don't read any of that information out loud, but please have a look at the description and the dates.
Yes, they're okay.
Being shown these four statements during your preparation session.
Yes, I do.
All being asked to confirm that you reviewed those four statements.
Yes, I do.
Do you recall being asked to confirm that those four statements accurately reflect your evidence and what you would say, if examined, about the events recorded therein?
Yes, I do.
Thank you, witness. And do you confirm that remains the case today, that those four statements accurately reflect your evidence and what you would say, if examined, about the events recorded therein?
Everything that I have stated therein is true.
Your Honors, the SPO seeks the admission of Preparation Note 1 with ERN starting 121136 and the English and Albanian versions of the four statements and the three associated exhibits listed on pages 4 to 5 of Preparation Note 1. These statements and associated exhibits were found to be admissible under Rule 154 in Decision F02328. All of these statements should be confidential, and I would ask that for the witness's protection, the ERNs, descriptions, and dates of statements 2 to 4 in particular, and the associated exhibits not be read onto the record, as they are identifying. If necessary, they can be referred to by item numbers in the charts.
Any objection?
No, Your Honour. No, thank you.
No, Your Honour.
No objection.
The note at ERN 121136 to 121140 is admitted. The four statements as set out therein in Note 1 and the associated exhibits are all admitted in evidence, and all will be assigned exhibit numbers.
Thank you, Your Honor. For item listed as number 1 in the preparation note 1, the exhibit numbers for the three parts will be assigned P 1200.1, part 2 P 1200.2, and part 3 P 1200.3. For the items listed under number 2 in the chart in the preparation notes, the sub-item 1 under item 2 in the note will be exhibit P 1201.1. Sub-item 2 will be exhibit P 1201.2. Sub-item 3 will be exhibit P 1201.3. Then the items listed under number 3 in the chart, sub-item number 1 therein will be exhibit P 1202.1. Sub-item 2 will be exhibit P 1202.2. Sub-item 3 will be exhibit P 1202.3. The item listed under number 4 in the preparation notes will be exhibit P 1203. The preparation note with ERN 121136 to 121140 will be exhibit number P1204. And then lastly, the associated exhibits, Your Honors. The item listed under number 1 will be exhibit P1205. Associate exhibit listed under number 2 will be exhibit P1206, and associate exhibits under number 3 will be exhibit P1207, and they will all be classified as confidential, Your Honors. Thank you.
Thank you, Madam Court Officer. Mr. Quick, you may proceed.
Thank you, Your Honor. The SPO sent a brief summary of the witness's 154 statement to the panel's parties and participants, which with your leave I'll now read.
Go ahead.
The witness, a Kosovo Albanian, was mistreated, beaten, interrogated, and detained by the KLA members in spring and summer 1998. KLA members accused him of being an LDK supporter, traitor, and collaborator. The witness also observed the mistreatment and detention of others in spring and summer 1998. Witness, as you've just heard, 4 of your prior statements have now been admitted and cover your experiences and knowledge of relevant events in great detail. The necessary clarifications and corrections were already made during your preparation session. So at this stage, I do not have any further questions for you. Thank you. Thank you, Your Honor.
Thaçi, defense. Boss.
Yes, thank you.
Thank you. You have the floor.
Thank you. Good morning, witness. Can you see me and hear me all right?
Yes, I can. Good morning.
You and I have met, but for the record, I am Simon Laws, the Victims' Counsel in this case. And I'm going to ask you some questions in just a moment, not about what happened to you, because the judges have said that that can be received in writing. So not about what happened to you, but about how you were affected by what happened to you. Do you understand?
Yes.
And at the moment we are in open session. The public can hear what you say, and so you must be careful not to say anything that identifies you. Do you also understand that?
Yes.
I'm going to start, please, with the physical effects of your mistreatment. As of today, are you still affected physically by what happened to you during your detention?
There are consequences, and I have to live with these things my entire life. Of both sorts of consequences, be them physical and psychological.
Can we start, please, with the physical consequences? How are you affected physically by the way that you were treated when you were detained?
I have nightmares every night where I relive what I went through. I suffer from anxiety, thinking that people will come and kill me. Sometimes I have these nightmares even if I'm awake. I'm not even able to watch certain type of movies because they bring me back to what I experienced and went through. Sometimes my children love to watch action movies and then I just don't stay there because I don't like. I cannot watch those movies. I'm also easily irritable.
Was the last sentence that you said that you're easily irritable?
Yes. For no reason. I have these sudden episodes when I relive what I went through. It just comes back to my mind. And at that moment, I lose my sound reason and I become upset or irritated. And so I step aside from people if I'm in a social gathering or if I'm at work or if I'm with people. So I need to step aside and recover my senses and calm down.
Are your family able to help you when that happens to you?
If I didn't have my family to support me, I would have ended up in a psychiatric ward. My children are able to now recognize the first signs of these episodes, so they will always come up with a proposal to take me away from those thoughts and say, let's go for a coffee or let's go for a walk outside the house to calm me down. And I'm very grateful for that to my wife and my children, because they understand what I have inside me.
What have you got inside you?
They understand what I experience when I relive things, because my children, not all of them know what I went through, with the exception of my son and my two elderly daughters. They understand they know what I went through, so they immediately take action and take me outside or do something different.
Have you ever sought psychiatric or medical help for your condition?
No, I haven't.
Your Honors, we're back in public session.
All right. So I thank everyone once again for your cooperation in allowing this special session. Because we were able to finish, we will go to the regular session tomorrow to begin at 9 o'clock with the next witness. Any questions by anybody? All right. We're adjourned until 9 a.m. tomorrow.
All rise.